All right, this is docket 25. Oh,
Yep.
sorry. I'm not used to seeing you over there. I'm used to looking at Nancy. Oh, nice to see you over there.
You too.
Thank you. All right. This is docket 25-3164FH. People of the state of Michigan versus Tyler Nicholas Brown. Counsel, your appearance for the record.
Good morning, Your Honor. Natalie Maycomb on behalf of the people.
And sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes.
Thank you. Put your hand down. Sir, you were on bond conditions. And those are the commitments. Where's the? Okay, yeah. Just looking for the benchmark. All right, and it says that you should be held in contempt for failure to appear for pretrial on August 27th, 2025. And I assume it should also add at any time thereafter. You were arrested and arraigned on count 1, police officer assaulting, resisting, obstructing. Did I swear you?
Yes.
Okay, sorry. And that's punishable by 2 years and/or $2,000. And then count 2, assault or assault and battery, a misdemeanor, punishable by 93 days and/or $500. Do you recall that?
Yes.
All right. Have you taken any medication yesterday or today?
No.
Are you supposed to be on medication you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
All right. Do you have an attorney that's been appointed to you?
No.
Your Honor, he does, Mr. Jackson has been appointed to Mr. Brown's case. I did speak with Mr. Jackson this morning. He did not see the email come through yesterday evening. He's off today. I was speaking with Mr. Cornish, trying to get an attorney here, but all of his people are tied with 54A right now.
Okay. So, sir, you have an attorney. You have a right to a hearing on failure to appear. That allegation, when you violate bond, it's not beyond a reasonable doubt. It would be by preponderance of the evidence, which means more likely than not. You do have a right to an attorney. You have a right to a hearing before this court. You have a right to a presumption of innocence until proven guilty by preponderance of the evidence. You can cross-examine any witnesses and evidence that people bring, and you don't have to provide a defense. But if you want to and you wanted any witnesses, the court would order those witnesses to be present. Any witnesses and evidence you bring, the people could cross-examine. You also have the absolute right to remain silent. Your silence cannot be used against you in any way. You can also choose to testify, but if you testify, then you would be subject to cross-examination. Do you understand all your rights?
Yes, ma'am.
All right, now tell me, I'm going to hold this until we're going to set a pretrial. We'll get you an attorney here and then we'll talk about this. Do you still live on 818 Buffalo Street?
No, it's 407 South Rosemary.
Just in 407 South Rosemary.
Yes, ma'am.
Who is there with you?
My aunt.
And is that Lansing?
Yes, ma'am.
And what's the zip code?
48917.
And how old are you?
I'm 24.
Did you graduate high school?
No.
How far did you make it?
Like 9th grade.
All right. Are you employed?
No, ma'am.
How do you support yourself? Your aunt?
Yeah.
You have other family?
No,
Where are your parents?
my dad, he was a drug user most of my life, so he isn't really in the picture. Same thing with my mom.
Okay, but you have a stable home with your aunt?
Kinda, yeah.
Well,
But
kind
yes,
of.
it's stable, yeah.
Well, why do you say kind of, sir?
It's stable. Stable as can be.
You have food, clothing, shelter.
Yes, ma'am.
You belong with her?
Yes, ma'am.
And so she's been providing for you?
Yes, ma'am.
Okay. Why aren't you working?
I don't know. I should have focused on it. You just gotta go. I don't know why. I continue to mess up and fail. It's just,
So how do you feel about staying in jail over Christmas?
I
I
would not
understand
like
it's the second best meal in of the year.
it. Suck. I don't.
So if I let you out on bond, I'm gonna give you some conditions. Now, I want to ask you a couple questions because I have some concerns. Have you ever been diagnosed with depression or any trauma? Yes or no?
No, ma'am.
But you think things are not going real well, right?
Yeah.
Okay. Do you know why they're not going well?
No.
Okay. The siblings?
Yeah.
Where are they?
Got two in Florida. Got two here in Michigan. I don't really know them like that. I wish I did, but I don't.
Are they older or younger?
I'm the oldest.
Do you know where they are?
Yeah. Oldest sister in Florida. She's actually graduating and actually working for NASA right now, so that's pretty cool.
Okay. Do you have their address?
No.
Is your aunt?
No.
So how do you know she's working for NASA?
I talked to my stepmother about it.
Okay. So can you get the address from your stepmother? Maybe connect?
Sometime probably, yeah.
So you're in contact with, you have a good relationship with your stepmother?
Kinda, yeah.
Well, you keep saying kind of. Why do you keep saying kind of?
Well, she hasn't really been in my life like these past like 10 years, but like when I was like 12, 11, she was in my life, so I can't really say we have the most solid relationship, but
Okay, but you can reach out to her once in a while?
yeah.
Okay. So have you ever held a job?
Yeah.
What did you do?
I worked for Amazon at the warehouse for a while.
Okay,
Before that, I worked at Little Caesars for 2 years.
okay,
I was the doorman there.
okay.
Pretty good. That's the only jobs I can recall right now.
So do you have a drug problem?
Yeah.
What's your drug of choice?
To be honest, it was methamphetamine and heroin.
Okay. So when was the last time you used?
A couple days before I got locked up.
So how are you, if you're not working, where are you getting the money?
Begging, I don't know, just homeless, begging, but if I'm given the chance to given the chance to be let out, I'm gonna focus up and get a job and try staying sober. I wanna pursue and go to rehab and stuff like that.
Well, sir, I could send you to, I likely will send you to rehab on this. I think you need rehab. I think you're depressed, or I think you're self-medicating. I'm not a doctor, but I see a lot of this. You had a shitty childhood. You have a broken family. You want things that are not going to happen. Sometimes those things make you stronger.
Yes, ma'am.
So if I let you out, I'm gonna have you drug test 3 times a week plus random on the weekends. You're gonna be able to do that, or are you gonna go to, or you want me to keep you locked up?
I'll do that. I'll do that.
Means you have to show up, sir.
I will, every time.
I get a sense you're depressed. I get a sense you don't give a crap. I get a sense you feel lost and worthless. We're gonna take care of that on through this matter, however it resolves. Okay,
Yes, ma'am.
but you're gonna have to cooperate with me and do the things that I order, because
Yes,
if
ma'am.
you don't, we have a jail. And I can get you treated in the jail.
Yes, ma'am.
You have to decide you wanna live and that you're valuable and you're worthy of living and that you can accomplish great things. Failure's okay. You know why failure's okay?
What?
Because you keep moving forward and you flip it into success, and failure just means it's a lesson you learn. And when you learn the lesson, that's success. It's okay to fail. There isn't one human being in the whole world ever in the history of the world who hasn't failed.
Yes, ma'am.
All failure is a teachable moment towards success. If you stop trying, that's a problem. Even if you keep trying and you keep failing, it's okay, because you learn, okay, I have to do something different, and you take the next step. So I want you to keep trying. Okay?
Yes, ma'am.
On behalf of the people, are you all right with me giving him a bond, PR bond?
Yeah, sure, I would just ask if Mr. Brown can provide an updated phone number, so I can send that to Mr. Jackson along with his, I got his address, but that way Mr. Jackson. can trust
Do you have a
him.
phone number?
I don't.
Does your aunt?
She does, but I'm not sure what it is.
Okay, can you?
If there's an emergency phone number, I'm pretty sure that's the phone number in file.
Do you have an email address?
Yeah,
Can I have that?
it's Tyler N. Brown 24@gmail.com.
Okay, can I give that to you?
Yes, ma'am.
So this Tyler Haley, I don't want you to talk about the case. Did you know this person?
No, I didn't.
You wouldn't know this person if you came in contact with them?
No.
So I'm going to still have a no contact order, and I know you don't know him, but let's say the two of you are in Myers and he says, it's you. I don't want you to say anything, leave your card, do an about face and leave.
Yes,
Can you do
ma'am.
that?
Yes, ma'am.
Is there any reason you left school? Like, do you have a disability where you can't study, or?
No.
How do you get around? Does your aunt drive you? You take the bus or what?
I take the bus.
Who else is in your aunt's home?
Um, one of her friends.
All right, sir. We're gonna give you a copy of this. And I need full compliance or else you will remain in the jail until this case is resolved. I'm giving you a $15,000 PR bond.
Okay.
You'll report to pretrial services as directed. It will be weekly, but you can report on Zoom, on the phone, just work it out with them. You don't have a card, they have lots of different ways. You don't always have to come in the building, but work it out with them. And however they want you to check in is how you'll do that.
Okay.
You shall not use, possess, consume, or be in the presence of illegal drugs, alcohol, or drug paraphernalia. You will show all prescriptions for medication from a licensed medical physician to pretrial services within 24 hours and take any psychotropic medication as prescribed. You'll follow your doctor's recommendations. If you have the need for any medication, we need that prescription. You can take over-the-counter medication as labeled on the bottle. You can take less, but not more. You will PBT and drug test 3 times per week. That will be on Monday, Wednesday, Friday, so you can plan for it, and then random on the weekend. If you are positive, then there'll be a secondary test so we can see if it is a false positive or real positive. If it's a real positive, you will be bench warranted again, and we'll deal with it, get you in treatment or do whatever it is I think we need at that time. You will also test at the request of pretrial services, law enforcement, any court officer, your aunt, or any adult you live with. So I don't think you need additional testing, but if they think something's going on, then you've got to do it.
Okay.
You shall not own, have in your possession, or under your control any weapon, gun, ammunition, imitation of a weapon. You'll not be in the presence of anyone who has those items. You will not be in the presence of any known gang members. You'll not wear any gang colors, gang insignia, or gang tattoos. You'll maintain your residence, and any address change will be reported to pretrial services, the court, and counsel within 24 hours. You will be part of a work-seek program to gain employment. You will appear for all hearings and proceedings. The next court date is the pretrial and bench warrant. And that's set for January 21st at 1 p.m. You'll stay in contact with your attorney. I don't know if this marries up with his schedule or not. If it needs to get changed, he'll let you know. So stay in contact with him. And apparently he'll email you or mail you or whatever. If you have a phone number, email him, or when he emails you, give him the phone number so you two can talk in person, or you can meet at the courthouse or whatever it is you need to do. Don't have a phone, okay? You will have no contact with Tyler Haley, Tylerhaley, the victim in this case, alleged victim in this case. You're also going to sign up for a GED/college program at LCC immediately. And you're going to also contact community mental health for counseling and evaluation for depression, addiction, whatever else you got going on. So while you are on these bond conditions, I want you to start healing Because if you end up on probation, you're innocent until proven guilty beyond a reasonable doubt, but for bond conditions, I have to look at your safety and safety of the public. And so I want to make sure that you're doing okay. So I want to give you the services now, and please avail yourself of them, because if you are doing well on them, that will, if you end up on probation, it will cut your probation shorter. All right, and you can talk about this with your attorney if you have any objections to this. You'll set a hearing in front of me, or we can talk about it in January. It's really important you sign up for the classes now. LCC will start in January. I don't know if their offices are still open or if it's gonna be the first week in January or what have you, but let's figure it out. I think your education is important. You need to get a job and you need to get over to community mental health, okay?
Yes, ma'am.
Is there anything I've told you to do that you think you can't do?
No, ma'am.
All right. On behalf of the people, anything I need to add?
There is at 1 p.m. Thank you.
1 p.m.
Thank you. No,
Thank you. That's all for this record.
What are we doing with violation?
It's just held in advance until the 21st. I just arraigned him on it, so. We're gonna get copies and, you'll get a copy, and then when you are released from jail, you'll have like 24 hours to meet with pretrial services and re-engage, okay? You know how to reach them?
Yes, ma'am.
Okay, very good. Have any questions?
No,
All right. Merry Christmas.
thank you.
I can do this. I'll put this second file. All right. This is docket 253748 CZ. Talia Jackson versus 900 West Townhomes, Einhorn New Traditions Lansing GP LLC. Counsel, your appearances for the record. Ms. Jackson, please raise your right hand. Do you swear or affirm the testimony you're about to provide to be the truth, whole truth, and nothing but the truth, and the penalty of perjury?
I just.
Thank you. You put your hand down, have a seat. Counsel, your appearance.
Good morning, Your Honor. Real Drew, back to the
Good morning. Counsel, this is your motion for summary disposition. You may proceed.
This is our motion for summary disposition under 2.116C8. This case relates to a residential lease that was dated July 2, 2024 for the property at 248, apartment 248 at 800 West Edward Boulevard in Lansing. The lease began August 1, 2024 and expired on its own terms on July 31, 2025. So it was a one-year lease. Interestingly, in spite of that prior to the end, she remained on the property until September of 2025.
Did she pay rent?
She did not. almost 2 months, at least mine is a month tenancy for about 2 months. She owes about $5,000, which is not an issue in this case, but by way of background. She filed a complaint in this case alleging that her lease is a consumer credit transaction that's governed by the Truth in Lending Act, TILA. There are 4 claims counts. One is fraudulent misrepresentation. The second is breach of contract. The third is unjust enrichment, and the fourth is violation of Michigan Consumer Protection Act. All those claims are grounded in the Truth in Lending Act.
Which you're not required to give,
Which
correct?
one I'm required to give.
So I'm not sure why we're here. I looked at this and I sat in the district court before coming up to circuit for 4 years and was in practice for 20 years. I don't know why this is filed here or filed at all.
Yeah, I agree, Your Honor. The nutshell of the of defendant's argument says a residential lease is not a consumer credit transaction and it's not governed by TILA. And that's about as simple as I could put it. I can go into more detail, Your Honor, but that is the argument.
You don't need to. I just always give people time on the record, but I've looked at this and I'm confused. Let's see what she has to say.
Okay.
Ma'am, what would you like me to know on why are we here, not in district court? And apparently you owe them rent, you were a holdover, but you're saying that they violated, but you stayed there. And there's a breach of contract and failure of consideration. Let me tell you, there was consideration, there was a contract. I'm very confused by this. So let me hear what you have to say.
Would you like me to approach?
Please.
First of all, I want to address the claims of me staying at this place until September. That is untrue. I had removed myself from the place shortly after I did my rescission.
And what date was that?
I don't have a specific date. I believe it was around June because I had another home to stay at. So I was not.
But you signed the lease, right?
I did sign a lease.
Did you pay rent?
I did pay rent, but there has been some breach of contract in the rent, if you allow me to express my argument.
Okay.
Your Honor, my name is Talia Jackson and I am representing myself in pro per. I filed this action because the defendant misapplied my rent, imposed charges without contractual authority, and enforced the lease in a misleading and inequitable manner. The defendant now asks that the court dismiss my case.
I need you to stop right there because we are a notice state. And you just said in that sentence a whole lot. How did they misrepresent? What did they do? What are your specific claims? Because you have to specifically plead that, and I'd like to know your specific claims.
Specifically, I paid my rent for the month. The defendant
Which month?
accepted that payment. I paid my rent for, what is it, the 5th month? May. I paid my rent for May. The defendant accepted that payment. They then unilaterally diverted my payment to rent of legal fees that were due prior to. The fees that I expressly stated that I would address separately with the court and that the lease does not authorize to be treated as rent. After diverting my rent, the defendant then treated my rent as unpaid and imposed penalties based on a shortage due to the defendant's actions itself. The misrepresentation in this was the rent was not accepted under the premise it would be applied as rent, but it was secretly applied elsewhere and used to manufacture a default.
How?
Under Michigan law, the
Ma'am,
state.
How is it secretly applied if you know how it was applied?
I did not intend on that to be applied to those fees. I also spoke with a representative for 900 West Town Home and let them know that those fees would be handled through the court.
So why were there legal fees that you owed them or that they claimed?
There were legal fees because I was going through a hardship and there were times where I was not able to pay my rent. I have been an tenant for this property for 5 years.
Okay.
I paid my rent up to act in good faith, and the remaining legal fees were still there because they wanted to start the eviction process. But there was never an eviction process. There was never a court date. There was never a court hearing. I always let them know that the rent would be paid.
Okay, ma'am. What did your lease say in regard to the charging of legal fees?
I believe the lease says that that I am responsible for them and that I can therefore go ahead and get them situated with the court if need be. But the payment that I sent in was not geared towards legal fees. It was specifically geared towards rent. So my payment should never have been applied towards legal fees that I did not apply those to at that time.
Okay, so how much money are we talking about?
As far as the rent
As far as
payment,
this whole case, I mean, the threshold here is $25,000. How do we get to 25,000?
because I am suing for the damages caused. I've been here for 5 years. I've been there for 5 years.
What are the damages? I don't care if you were here for 100
The
years.
damages
What
are-
the damages?
My legal fees,
What legal fees?
my gas,
What legal fees?
the fees that I have to pay here with you all, the misconduct
So
and
let me get this, the filing fee, so that's
the,
what, 100 and
the
something?
filing fees,
Okay.
correct.
And,
The fees from prior leases, if that is allowed, prior leases, I want to get
wait a minute,
restitution. I returned this property to them. Actually, I did not return it. The property was therefore taken once they found a new tenant because I did not communicate with these people due to it being a legal action.
Okay.
I communicated through paperwork as I should.
what rent do you want back? Not the whole 5 years.
I want at least my year lease rent because the contract has been breached.
You live there?
I lived there for up until June. So before the lease was, up until June, before the lease
So
was,
you want some of that money back?
yes.
So you want to live for free?
I don't want to live for free.
You're not
I just
getting-
have been
You're not getting that money back.
mistreated in this scenario
How were you mistreated?
because they have manipulated payments.
Ma'am, this case does not, first of all, rise to the level of $25,000. It doesn't appear to me that you have evidence to support your claim. And the claims that you have pled are different than what you're telling me now. I'm granting this motion. If you want to refile it, do it in district court, get some evidence, get a lawyer. There is no grounds for it to be here. And if you have a claim against them, they say you owe legal fees and you say you don't. I mean, again, that's a district court. It's not here. It doesn't rise. Counsel, is there a $25,000, beyond $25,000 that either you're claiming or she's claiming? Okay, so this, I don't have jurisdiction for this. This belongs in district court, ma'am. There's no grounds here for this case to be in front of me, and what you've claimed in terms of the Truth in Lending Act doesn't apply here, so,
Yes, that is absolutely correct, Your Honor.
okay.
The,
So
the Truth in Lending Act may not apply. I understand that you guys, have addressed that situation. But this is also backed by Michigan common law.
okay, again, tell it to the district court judge. This matter is dismissed with prejudice. Go into the district court.
Thank you.
Thank you.
Submit an order of Sunday.
Thank you.
Thank you.
Ma'am, there are agencies that can help you for free, the Landlord Tenant Resource Center and other attorneys you may want to contact to assist with this, all right?
Thank you.
All right. There are no words for that case. Good morning. Good morning. Perone versus Lansing Board of Water and Light, the city of Lansing. counsel, your appearances?
Michael Ferone, representing myself.
All right, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you.
And Randy Kleiman on behalf of Lansing Board of Water Line.
Thank you. Counsel, this is your motion to exclude newly claimed but not produced documents and brief in support. So let me,
There are 4 motions.
and okay, there's 4, but let me just address this first one. Is there, so on behalf of defendant, is there evidence that you have not turned over to him?
No, Your Honor. In our brief, and I'm sure the court's heard a brief, we explained that we filed a motion for summary just before discovery closed. We had pending depositions. We were granted the motion for summary, but it took about 5 months to get, it took a couple of hearings and about 5 months to get the order entered. Mr. Ferone then appealed the motion, the order for summary disposition.
All right, I don't mean to interrupt, I think Your Honor's talking about count 4.
I'm looking at what the newly claimed but not produced documents.
Oh, okay.
I'm sorry.
Yeah, I think
Yeah,
I'm
that's
on
what he's
the
talking about. I
Thank
believe.
you.
Yeah, is that okay? Is that better? Sorry. So, the court, Judge Jamo ruled and granted summary disposition on the entire motion, all of the counts, and dismissed the counts.
Right.
And then it went to the Court of Appeals. Took frankly, a couple of years, and the Court of Appeals comes back down. Court of Appeals rules that there is a genuine issue of material fact, and that the issue of material fact is essentially the length of time that the Lansing Board of Water Lines equipment was in its current location.
Okay.
So we dug deeper, and among the things we did was we dug internally and we dug externally. And what we found were additional documents that will bear on the issue.
Okay.
And so I immediately, when this case got back to this court and we had the status conference, I informed counsel that we, based on the Court of Appeals ruling, we went and dug some more. We found a few internal documents, but the majority of what we found were photographs from the assessor's office that substantiate our position. And I turned those over to counsel.
To Mr. Ferone.
We're well in advance of trial and pre-trial, and he's not prejudiced in any way by this information.
Okay, but there's no outstanding documents that he hasn't received, is that right?
No, Your Honor.
So I'm right. So yes, I'm right. That he's
There is
received
nothing
everything.
that we currently are aware that he's not received. I just want to be clear and transparent on the record. Sometimes you find things in advance of
Right,
trial.
there's ongoing discovery, right? So, but everything you have, photos, whatever, everything you have, he's been provided?
Yes, everything we have and we intend to use has been provided. As the court knows, the Lansing Board of Water Lines is a large organization. A lot of these documents go back 20, 25, 30 years, and it takes time sometimes to even know where they are. But we believe we've located everything and have turned it over.
So which documents are you talking about? I just want to take these one at a time, and I didn't mean to interrupt you, but I want to see, I mean, obviously, they didn't turn something over, they need to. And you want to exclude newly claimed but not produced documents, and the not produced part is the concerning part to me, as you know. So are you claiming that there's still information they have not produced?
Well, what occurred was at the status conference we had in October, in the
Right.
hallway, as opposing counsels acknowledged, he told me, well, we have found new items. Okay, it was after I filed the motion in front of Your Honor that he produced, he starts emailing with the new items, I guess. I call them new in quotes. They're not new, they go back decades.
Okay,
They've been laying around for decades. His office, or they're real estate attorneys. They hold themselves out that way. They're licensed real estate brokers. They know the assessor's office. They could have gotten these long ago. But when I filed my motion, I didn't have any of this.
okay,
So it's after I filed my motion, he starts emailing. And the problem is, and I understand, our discovery's ongoing, et cetera, et cetera. Okay, but what is he giving me? He's giving me something titled thumb, which I can't open. He's giving me, I didn't file with this court, everything he's provided, but I thought this was illustrative, so I filed that Excel sheet. I don't know what that is. And so what I'm asking is, either say, look, this case went to the Court of Appeals. They issued a 39-page opinion. This case was pending for Judge Jamo for a long time. They filed their summary motion when they filed it. That didn't toll discovery for 3 years. I mean, discovery in this case closed 3 years ago, I think. So, I'm asking the court to either say, enough. What was turned over during the initial discovery period, that's what we're gonna go with that trial. Or if the court, would allow them to submit quote unquote new evidence, then at least let's do it, let's put some rules in place. Let's have a deadline. Let's have him set out what he's giving me, describe it. I'm not asking for a lot, just what it is, where it came from, who he's gonna call, what it means. I don't know what some of this stuff just appears to be designed to confuse me. And the way things are now, I don't know what's in that thumb drive. He can sit.
I got it. So,
If I may, Your Honor.
well, let me just ask you, is there, aside from you, counsel, is there someone at the Board of Water and Light, and I know it's an enormous agency, or is there someone who could be deposed to satisfy counsel in terms of what it is, where it was found, and all of that, and can you put it in a different format so he can open it?
Well, let me respond to that. And this case has a history of this.
Right.
Had I known there was any document he couldn't open that we gave him, we'd find a way to get it to him. I want to use these documents. It's not designed to confuse anybody. It's not designed as a ruse. Here's the issue that I think we're losing. If this were any other case and we were coming up to trial, and I believe that what this court is going to do, in fact, I think we have been compelled to exchange documents we intend to introduce at trial. We continue, to come across things that are relevant to the issue that we may use in any case that happens. The issue is whether he's surprised and prejudiced by any of it. He's trying to use this argument to keep us from putting fair evidence before this court on what the Court of Appeals called the genuine issue of material fact.
Well, I'm not cutting off. First of all, you both get to use whatever right now. We can have a cutoff at trial, and then you can show me good cause why something was just found or whatever for both sides before trial. I'm not excluding this evidence, okay?
Yeah.
And I think it's fair. Did I give you a trial date? I don't remember.
You did. We have as I recall, I'm doing this off the top of my head, I think it's a March 26th pre-trial, and it's
Okay.
April 10 maybe trial date.
Okay, so we have a few months here to sort all this out, to get it in formats, to do depositions, to do a deeper dive if needed for both of you into whatever documents you need. What else can I do for you, sir? They're gonna give it to you in a format that you can open, and you can depose whoever is the keeper of those records. That would probably solve some of this.
That's what I understood it, Your Honor. I think Your Honor asked Mr. Kleiman, who can Mr. Frome depose to answer these questions, and you can see I still don't have an answer.
Well, he's getting there. I'm taking you both out of order, but it's sort of my way to dive in, because I read these things, but it's always the things that I don't read that I want answers to.
Correct.
So
Well, first of all, I'm an officer of the court, and
Yes.
the court rules compel me, the discovery rules compel me to give
Correct.
him responses to what he's asked for. Second, he has scheduled, so you recall that his argument is that discovery is closed.
well, it's
Okay.
not. I've opened it.
Well, I know it, and I'm okay with that, Your Honor. I think we ought to establish a date, a specific date to extend discovery to, maybe December or January 31. Okay. I don't have any problem with him deposing a keeper of the records, and I would have to locate the various people who've located these documents if he really wants to depose them. I suspect he doesn't, but if he does, if he wants to ask the keeper of the records, if you look for these records and where these records, found by you, fine, he can depose them. He will continue to talk about the expense incurred in this case, and it's been significant. Because we do this instead of getting to the two issues. In this case, is there an easement and what's the scope of the easement? Nonetheless, if that's what we need to do, that's what we'll do.
Your Honor, all I really,
We just need it. I'm okay with.
All right, your cutoff for discovery is gonna be February 20th,
Okay.
2026, and I need somebody who's the keeper of the record, or a couple names or whatever, whoever has these records, so he can be satisfied what they are, what they mean, how they fit in, And if that's the extent of what's available to him to review. So I know the Board of Water and Light, complicated, lots of people involved, different sectors, you're in so many buildings. So is there one person, or is there a group of people, or is there a department, or what?
We deal with legal over at Board of Water and Light, and I frankly don't know who all the people are who
Okay.
this would be, but what we might be able to do is we may be able to give a specific response to a discovery request indicating that these are all of the records that we have been able to locate. I'm not quite sure what counsel is looking for. What exactly does he want to ask the keeper of the records?
He keeps using the phrase keeper of the records. I don't think I use that phrase. I did say where they came from, and what they mean. What I really would like to know is, what am I being given? What is this? What do you think that this means? Basic questions. If he could do that in a written form, I probably would not need to depose.
No, you're.
Why don't you do some interrogatories and have some questions like that, and then he will respond if if you're still not satisfied, you certainly can do a deposition or whatever, you can come back to me.
That's fine.
Can
I
you do
appreciate
that?
it. I
And
appreciate
then,
it.
Can I suggest that by a certain date, he asks me whatever questions has with regard to what's been produced. And I'll get the information for him, you know, a huge chunk of what he's been produced that we intend to use are City of Lansing assessor records that we located at the public library. And we got them certified. And one of the things that took some time to get it to him was to get the certification of these records.
okay, so, I've given you an extension till February 20th, but sir, you need to get those interrogatories, sometime in January, so that you guys can do the necessary works, otherwise we're pushing the trial date. And I don't want to do that.
That's fine, Your Honor. That's all I'm
Does that
seeking.
help?
It does. It wasn't clear to me that discovery was entirely reopened, but now I
Well,
understand
I'm
it is.
opening it, I think that it's based on all this.
Right.
And then you've got a motion to compel depositions, just schedule them. If they don't comply, then the immediate answer, I've opened up discovery.
To be clear, Your Honor,
Yeah.
we have dates.
Okay,
We haven't
great.
received any notices of that.
Well, I can take care of that now, Your Honor. As of 2 days ago, we did get dates.
Okay, good.
And I'll hand opposing counsel the notices.
Okay, the other issue is that you want me to come do a, is this a jury trial?
Except for a jury trial, I am willing to waive jury. I think opposing counsel and I are still talking about that. So,
Here's the deal. I'm always happy to do site visits. And if you end up with a jury, we can certainly have the jury do the site visit under court supervision. There's a provision for that. So either way, you get your site visit. So that's also granted if that's what you're asking for. That's not a problem.
My response to that was that usually that's done at trial, because the question is whether it's helpful to the trier of fact to actually do the site view. I suspect it's not gonna be, but I think that's a decision. I think that issue ought to be taken under advisement, and he can re-raise it at trial.
Well, it's preserved, and if it's helpful, I mean, I often find it's helpful. I don't know, but sure. Is there anything else? Is there something I missed?
no, that's all I'm trying to do, Your Honor,
Right.
is to preserve the
So-
issue. It doesn't have to be decided today.
That's great.
Fully agree with that.
Okay, so have we addressed all of your motions? Is there anything else that I can
I
address?
think we have. I mean, the first one, count 4 is withdrawn. That's not, I think we're good. I don't know if there's anything else Your Honor needs me to address.
No, are you gonna draft the order?
I will.
Okay, so if I might, there actually is one more issue. That
Okay.
is the withdrawn motion, and you asked about whether this is a jury trial. The council has agreed to dismiss count 4, the surface drop hazard, and he references that in his motion that he's now withdrawn with regard to documents with respect to that count. I want to be clear on the record here, whether count 4 is in fact withdrawn or dismissed. so that I know how to prepare for discovery and prepare for trial.
I think that's a fair.
This is a game that has been played. If you read the motion.
There's no, here we go with the
Okay.
insults. There's no game. I think that's a fair
Okay.
question.
You said it's a fair question. Can you answer, please?
Yes, count 4 is not withdrawn. I looked at the service drop. It appears that it has been raised. Opposing counsel, for the first time in the status conference, said they raised it. In fact, you'll notice, in fact, in the filings, I used the word appears. I don't know if it's been raised or not. I'm not going to go up there in the middle of the winter to measure it. So I said to opposing counsel, I'm going to, just to negotiate this away, I will compromise. This is all the written filings. I will compromise and just assume it's been raised and assume that it's compliant with federal standards after you made me sue you to get it accomplished. By the way, these arguments I've made in the motions in front of your honors, that they cropped the photograph of that service drop and manipulated and backdated a letter 2 years to make it look like there was never a problem. That was all presented at the Court of Appeals. It was all laid right out. He had his time. He responded to the Court of Appeals that Mike Frone's a liar. Mike Frone's a game player. We're hearing it again. And they looked at it all. 3 appellate judges. They have 3 judicial assistants. They have a research division. The idea that I can fool the Court of Appeals is crazy. They looked at it all, and here we are. They sent it back. They didn't think that count 4 was trivial. But nonetheless, they said, okay, just to simplify this trial, it looks like it's raised. All I wanted were 2 things. 1, send me documents showing that the problem is fixed. And 2, when it's dismissed, but the judge reserves, at the end of this proceeding, the opportunity to determine whether I was a prevailing party. Why is that important? Because he did this every motion in front of the court today. He asked for attorney's fees, but it's in front of Judge Jamo. Every single motion, response to motion, he's asking to have me sanctioned. It's 4 years. He wants to talk about game planning, 4 years of abuse. That's the city of Lansing. He doesn't act like he's representing the government, constantly asking me to be sanctioned, constantly trying to intimidate me. That's all he does. And when this case comes to an end, if he prevails on one issue, no matter how petty, he's going to run in front of your honor and say, I prevailed, your honor, sanctioned Mr. Frone. And all I'm asking is, if that happens, I don't think it's going to. If it does, I'd like to be able to say, wait a minute. You left a wire hanging over my garage. This was within feet of my house, hazardous wire. You told me in response to it, Mr. Mattis told me, not Mr. Kleinman, don't call customer service. That came up during oral argument. They saw that. And you let it hang there. If that garage had caught on fire, and by the way, if their theory, if they're experts, they're going to call, they could have. We'll go into that at the trial. My house could have caught on fire. And my neighbor's house could have caught on fire. And so that's all I asked was, let the end of this proceeding, let the judge decide whether I was a prevailing party on that. Let the judge look at the photos you submitted to Judge Jamo, because this is a new case for your honor, and to the Court of Appeals. And he said no. And that's fine. He can't say no. But you know what else he did? He gave your honor a proposed order to sign to just dismiss it on his terms. Under what court rule is that allowed? That is a count that the Court of Appeals sent back for a trial. He doesn't like my terms for dismissing it. That's fine. He doesn't have to. We can have a trial on it. What court rule allows him to ask this court to dismiss it on his terms? So no, count 4 is allowed.
Okay, so, but I'm understanding I'll address you in a minute, Mr. Henry. I'm understanding 2 different things. Well, first, let me address the attorney fees. I know that's irritating. I also know that I always asked for attorney fees when I was in practice for 20 years. And the reason, and you know this, counsel, is because sua sponte, the court can't do it. And so both sides preserves it, and it all comes out in the wash at the end. So as judges, we know how to do that. We know how to argue it. There's court rules, and that is an issue. And I understand you want to preserve that, but I also heard you say, maybe I heard it wrong, so please correct me if I'm wrong. I heard you or understood you to say that in regard to count 4, if they can provide proof that the problem's fixed, then it's dismissed but preserved, because then you would be the prevailing party on that? Is that the summary? Did I get it wrong?
We would dismiss count 4 if he could, provide documents showing it's compliant with the federal code, and I'm not asking him to agree that I'm the prevailing party.
I got it. We'll decide that later. So I just want to be clear on that. So as you go through discovery and you do your interrogatories, please have him put that in there. And then, because you'll both then know what you have to prepare for trial. Because if count 4 is resolved, however, we don't have to deal with that at trial. And you both need to know that. I need to know that. The jury will need to know that. So if the problem's fixed, you can have your proof, do a stipulation, do whatever, and preserve the other issue for later. But I think counsel is rightfully so asking to limit the issues for trial. So if you're satisfied then that the problem's fixed, that's off the table except as to cost, which I'll figure out later. Is that right?
Correct. In fact, we submitted a proposed order, which he could agree to it today. I could read it into the record. It's,
If I might, Your Honor.
You might.
I think I can clarify this.
Thank you.
He always, if he is a prevailing party, if I did something sanctionable that would give him fees under some rule or statute, he always has the right to come before this court and ask for you to determine he prevailed on that issue and I should be sanctioned and he should get attorney's fees. I don't want to muddy up. He has agreed to be, he has the information. There's no new information to get. He's got it. He's looked at it and he has said in his own pleading, it looks like it was raised. Now, let me be clear. It was never too low, but the board just decided to take this issue off the table and raise it. All right, that's where we are.
Okay.
So the point is, I don't care if he raises the issue of attorney's fees and sanctions and whatever later on. I just don't want the language he had in his proposed order. He wanted me to sign. So there is no question that this board has the right to sanction me if I file a pleading or whatever in contravention of the rules.
Yep. So have you seen the order that he has, or would you?
My order was attached to my response, and all it does is dismiss the count. It doesn't get into who's a prevailing party or right to reserve a prevailing party or any of that, because I think that's confusing. Who knows? We may be back in the Court of Appeals in this case, and I don't want there to be a confusing order.
So
yeah, I guess at this point, look, until the winter passes, until I can send somebody up there to measure, we don't know what he did, so. We're talking
right,
about.
So he's under oath, and he just indicated in court, he has no evidence that drop is in contravention of the law or code. And they don't, and he doesn't. He keeps trying to force us to produce evidence that it is. It's he's the one who brought this lawsuit. It's his claim. He has to prove it isn't. Now, this is not a motion for summary, but this court can actually, under the rule on that issue now.
sir, you have said that it's off the table, but you want to deal with costs. Costs are down the road. It's always preserved, as in my courtroom anyway. I don't know what other judges do, but as long as you are asking for it, again, sua sponte, there's problems with that unless it's sanctions, and then I can certainly do that. But anyway, it sounds like you don't have an issue with anymore with count 4. So why not grant summary or come up with an order you both can agree to?
Well, this is what I've offered. It is hereby ordered that defendant having raised the service drop described in count 4 is hereby dismissed without prejudice. It's not the end of the case. On grounds of mootness, with plaintiff reserving the jurisdiction of this court to determine the tax costs in its reasonable discretion. Favorite plaintiff is the prevailing party. There's nothing in there that declares me to be the prevailing party, and we could enter that order today. It just reserves the issue. That's it.
But it's already preserved in total for all counts in all actions in this case. And I think in the motion for summary, we don't generally put that.
That approach, Your Honor, I have a proposed order. It's the same one that was attached to the response to the motion. Thank you.
So, sir, you've had an opportunity to look at this. It just takes out the cost issue, we made a record here, and I will just determine costs on this whole matter at the end.
Can I, at a deposition of the person who dealt with this issue, ask them questions about count 4? Because that's gonna come up with the deposition.
Well, it's dismissed without prejudice, so I suppose if you found new evidence, you could modify based on some kind of change.
Very good. If the
So-
order, if the order you're, I apologize, if the order you're about to sign dismisses it without prejudice, if that's the case,
Dismisses it.
This one I think doesn't fit, you would have.
I know, but I'll do it without prejudice, and then it takes all this off the table, so if he wants to do a couple of questions or whatever, and further, I think we're okay, doing it that way, and then, it's not coming into play at trial unless there's some new evidence or reason, and you can petition the court, we can make a further record, that cleans up this matter, so I'm simply, adding without. And I'm signing this. That takes one issue off the table, at least for now. And I think defining your issues with such a complex case and with some work to do is good.
I appreciate that. Norm.
Is there anything else I need to address that I haven't on behalf of plaintiff?
There's one matter that if I could bring it up, it might be helpful. If not, though, it occurred to me that a settlement conference with Your Honor could be very helpful. Here's why. Back in March of 2023. Where's that there? Sorry. After Judge Jammo granted a summary motion, there was a sanction motion pending. They wanted, I think, well, they wanted tens of thousands of dollars. I was sick of this case. I had a lot of work to do. Against what my wife's telling me, just do the appeal. I should have listened to her as always, typically. I said, no, I had it, and I offered to, I threw in the towel, offered to throw in the towel. All I wanted was their chief forester, John Rademacher, to oversee the destruction of my backyard. That's all I asked. So that was, he rejected it. I was shocked by it. I couldn't believe it. And I said, fine, my office is wrong. Here's what I'm getting at. In an email that I had with him about this, I think Your Honor has it. I said, that was still shocking to me. And did you convey that to your client? And he had his client, which was Mr. Mattis, and somebody else had added in the email chain. And then when that subject came up, he takes them off the email chain. It seems to me there's a problem here because this case could have been resolved then. Now that offer's never coming back, but this case should still be resolved short of a trial. We have an offer on the table. We've had it on the table for years. And
Have you gone to mediation, case eval?
We
Is that
have.
something? Are you gonna go back now based on this?
no, I think, to be honest with you, I think what might be helpful would be for Your Honor, if you,
I'm happy to do a settlement conference.
I think it would be great because I
Great, when
think,
you guys finish discovery, if there's nothing else that you need to fight about on the record, let's just set that in front of me. And we'll go in the conference room and do it. I don't have a problem meeting with people ever.
Your Honor, if I might, please, with respect to this issue. I sit here quietly, well, all sorts of things are alleged to have occurred. I'm going to represent to the court that most of it is inaccurate.
I understand that.
I sit here quietly, Your Honor. I bear it over and over again. It's been going on since the commencement of this case.
I've had.
All right. This is a very personal case. I get it, sir. No outbursts. I can
No,
call.
I-
He's the party and he's the attorney. He does not recognize the line between those two things. But here's the point. I'm willing right now to go to a settlement. We can go right back to chambers right now and do a settlement conference. The two issues here, whether there's an easement, and actually in his request to admit, he admitted there's an easement. And what is the scope of the easement? That's all that is the issue in this case.
All right.
We had 7 counts. That what he misses is the Court of Appeals upheld the dismissal of 3 of the counts, the tort claims. And so here we are back again on the core of the issue, which is what he should have brought in the first instance.
Okay.
He brought the litigation, we didn't. So we'll do a settlement conference anytime. The issue, though, is going to be very simply the scope. All the rest of this is smoke. The scope, what can the board do with respect to the easement it has over their property? It's that simple, and we'll talk about that. And I might as well now do this on record, with regard to, he wanted us to ratify.
Why is Mr. Kleiman not under oath? I have to ask. Why am I under oath? He's never
I'll go
under oath.
under oath.
I think maybe.
Please
you should-
raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
Thank you. And the reason I put you under oath, sir, is because you're representing yourself. You're sort of the client and the attorney, and so I just do that because Court of Appeals is funny on a lot of things, and I don't want to miss a step that I could have taken. So anyways, you're both under oath, and as counsel, you have to
I have a-
speak truthfully to the court
Right, I
anyway.
have a duty.
But here's the thing, I think the settlement conference, I appreciate you saying we can do it now, but I think council's not going to be satisfied until there is the further discovery. And so it's premature to do it, but I'm happy to do it for you. And I agree, there's only the two issues.
There are, and we've got a lot of spending coming up, and he will complain, that yes, we may come back and ask for sanctions. He will complain that we're consuming and spending all sorts of money, but it is not us. I am very happy to go, before we spend the money on additional discovery, let's get a settlement conference and see if we can get this case settled. I don't want to get into too much the settlement discussions, especially if this court ends up being the trier of fact, because that will be raised as an issue later on. But we were very close. Counsel is right. We were very close. And thank you. So I would urge the court, maybe we can, I'm not very hopeful given the history of this case, but I'm very willing, and my client is very willing to see if we can get settled.
Okay, well, schedule me in as soon as you all have what you need, because I think the plaintiff needs some information to come willing to negotiate in a settlement conference. Am I correct?
I would be willing to do it today. I'll be willing to do it after discovery. I think the way your honor is approaching that is entirely fine. Appreciate it.
Well, I don't want you to, I don't want to go back to the settlement conference and saying woulda, coulda, shoulda, needed. I want you to both be satisfied you got what you needed, you have your questions answered, and then let's go to the table and work it out. Hopefully short of a trial. If not, we go to trial.
Your honor, I appreciate that. I appreciate your time. I agree.
Could I propose that we get an early settlement conference, maybe maybe in January with the court?
Sure.
I mean, it's as bad as finding out 15 minutes that we're not going to be able to have a productive conference.
Well, the discovery is closing February 20th, so you want an end of January, beginning of February?
I'd like it beginning of January, Your Honor. Again, there are no new issues to discover. We claim we have a 15-year prescriptive easement over his property. He's seen the documents that we have. And and the testimony is going to be the testimony. He's not going to get anything new on those issues.
Well,
So then it goes to scope, and scope is he simply doesn't want us to trim to our scope. That's the issue. He knows about our experts. He knows what their testimony is going to be.
Your honor, I'm not the one turning over new evidence. I'm just trying to understand what he's turning over. Okay, so he's being accused of raising new issues and searching for things.
here it is. He's not gonna be happy until he looks at those documents, sir. So if you get those documents to him and you're all ready, he's willing to do the scheduling or the settlement conference, then I will advise my staff to fit you in, and we'll give you an afternoon or whatever it is, however many hours you need. I'll fit into my schedule. I can juggle other things. I think it's important we do that, whether it's in January or early February, what have you. When you two are ready, you let me know. Because I think you need your documents, right? So we could go do it today, but you don't have your documents, and I don't want to hear that. I want you all to have, all your toys in front of you, and then I'll see who gets what, okay?
If I can, Your Honor, we'll more than likely have trouble with the order. Can I recap what the order would be?
Which order?
The order after the hearings today.
Sure.
Okay, so there are 4 plaintiffs' motions. One was withdrawn, which we call the first motion, plaintiff's motion to compel documents pursuant to count 4. We've given those documents, that motion was withdrawn. Second one is motion and supporting brief for the trier of fact. I think that's a review I think the long and short of that, the answer would be that it's.
It's held in abeyance.
It's held in advance, correct, okay. Plans motion to compel depositions, there are depositions scheduled, but basically the response to that would be the court has extended discovery their due dates.
Yeah,
And it would be wide open discovery, so depths would be allowed,
and you'll both comply with,
absolutely.
not just the depositions, but with the court rules and the laws we all operate under, that any newly discovered evidence will be transmitted immediately.
Right, and then the plans motion to exclude newly claimed documents, that's, you said you're not gonna exclude any such documents.
Right.
Okay.
Is there anything else
So
you
that's the
wanted?
line.
If that seems to be the totality of it, is there anything else that has been missed, Mr. Brown?
We should probably include, the court granted, I think we're all in agreement with the settlement conference.
Sure, court will hear a settlement conference early 2026, as soon as the parties are satisfied they have all of their discovery. Or whatever discovery they need for a settlement conference. It might not be all the discovery, but we
The,
want to do it prior to the end of discovery, I think.
the newly, claimed evidence, I think that's taken care of with the opening of discovery. They can ask questions about
Yes,
whatever being given.
whatever you need.
Well, but the motion was denied, but there is this new discovery extension.
Correct.
So with that, Your Honor, no, I apologize if I
It's okay.
show emotion. I mean,
It's hard to be your own doctor or your own lawyer. I get it.
there's a lot that's going on. He talks about the council were dismissed. Yeah, they were dismissed, you know. At the deposition he took of my wife, he's asking her, were you wearing pink pajamas? He needles, he
She
antagonized.
claimed that she was photographed by the board and went out there in her pajamas.
Yeah, you know,
Okay,
there you go,
okay. Well,
pink pajamas. So,
I don't care about that issue unless it's coming before me. So let's just be the civil
I agree.
lawyers that we are, okay?
Thank you. Thank you, Your Honor.
Thank you, Your Honor.
So he can't hear you. Now they can hear you.
Oh, well, they'll all have a lot to tell me, so we better not.
Hey,
Hi, Gidget.
Gidget.
I said, that looks like Gidget.
It is.
And
Hi,
he was like,
Chris.
oh,
Hi, everybody. Congratulations, Chris.
that's Heidi.
Hey,
Heidi, come say hi. Hi.
That's his wonderful paralegal.
Hey, Swag, G-Man, Ellie, how you doing?
Doing well. How about you?
Doing good, thank you.
Good. Congratulations.
Thank you, appreciate
You're
it.
welcome.
Yeah.
We won't stay unmuted for very long. We're not with that.
No, you're good. Thank you for dialing in,
Yeah,
Thanks for setting it up. I'm glad to be here.
for sure.
and Dad's back with Judge Aquilina.
I'm sure he is.
Uh-oh, two tossers. No.
Just Nicole's up there. He was like,
I think they should understand. And are you for clerks or?
I'm a fill-in court recorder.
Steve, and who's the picture taker?
Do you want, I can be a picture taker.
Okay, so picture taker, you get to, as long as you're quiet so the court reporter can hear, you can come here because as lovely as the back of his head is, I'm sure you want some pictures front and center, so you can be here. You can also just quietly walk in back of me and go on that side. So jury box and you up here. And then you take pictures after.
Okay.
It's like a wedding, don't worry. I got control. I do a lot of this.
It's almost like you know what you're doing.
Yeah, almost.
Yeah.
All right. Nice shirt.
Thank you.
Front row or the top.
All right. Okay,
Wherever.
so and if you want, so you can move around, whatever, or if you want to go.
Yeah, that should be perfect, right here.
Okay, yeah.
Thank you.
Yes, no problem.
I don't think they can see the.
And then,
Oh,
can you move the
Yep,
camera?
I'm gonna fix
so-
that right now.
there we go, perfect.
Good work.
All right, so Brian, at the end of this, maybe we can send on the film.
Yeah.
The Zoom, and I think it's, I don't know how it works on YouTube, but I've not done that, so.
They're recording day, so we can send it to them.
I'm just thinking.
Road troops.
No, I'm just letting you know, so they have the full Zoom thing as well.
Can you see? Can you move it over a little bit? So, yeah.
Yeah, I was trying to get it so when he
Yeah.
I can just move when he
That's
approaches.
good. Okay. Ignore my messy desk, we've been in trial and. It won't show in the other pictures. All right. This is in the matter of the petition of Jonathan Christopher White. Who brings this petition?
I do, his father, Jonathan Toby White.
On what basis, counsel, do you bring this petition?
On the basis that I've known him almost all his life, and that I have been with him through his service in the Navy. I've been through his law school experience with him, where he was stellar. I've been with him, he's now JAG, and I've been with him from a major law firm in New York and with a major law firm here in the Lansing area. And he's done nothing to embarrass the practice of law or his family for that matter in all of those 40-odd years. So I am proud to be able to be the one to stand here and petition him into the State Bar of Michigan.
It is truly an honor to have you here, and as a parent, I have not had the honor of swearing in any of my children or making a motion for them to be sworn, because none of my children are interested in the law, sadly, at least not now. So, and I've known you a long time. And I know how very proud your family is of you and your father, who kept me updated through all of your adventures. And your father is in front of me all the time, doesn't always win his motions. He wins a lot of them, but not all of them. However, today, his motion is granted. Please raise your right hand and repeat after me. I do solemnly swear
I do solemnly swear
I will support the Constitution of the United States
I will support the Constitution of the United States
and the Constitution of the State of Michigan.
and the Constitution of the State of Michigan.
I will maintain
I will maintain
the respect due to courts of justice
respect due to courts of justice
and judicial officers.
and judicial officers.
I will not counsel or maintain
I will not counsel or maintain
any suit or proceeding
any suit or proceeding
which shall appear to me
which shall appear to me
to be unjust,
to be unjust,
nor any defense
nor any defense
except such as I believe
except such as I believe
to be honestly debatable
to be honestly debatable
under the law of the land.
under the law of the land.
I will employ
I will employ
for the purpose of maintaining
for the purpose of maintaining
the causes confided to me,
causes invited to me,
such means only
such means only
as are consistent
as are consistent
with truth and honor,
with truth and honor,
and will never seek
and will never seek
to mislead the judge or jury
to mislead the judge or jury
by any artifice
by any artifice
or false statement
or false statement
of fact or law.
of fact or law.
I will maintain
I will maintain
the confidence
the confidence
and preserve inviolate
and preserve inviolate
the secrets of my client,
the secrets of my client,
and will accept
and will accept
no compensation
no compensation
in connection with my client's business,
in connection with my client's business,
except with my client's knowledge and approval.
except with my client's knowledge and approval.
I will abstain
I will abstain
from all offensive personality
all offensive personality
and advance no fact prejudicial
and advance no fact prejudicial
to the honor or reputation
to the honor or reputation
of a party or witness,
of a party or witness,
unless required
unless required
by the justice
by the justice
of the cause
of the cause
with which I am charged.
with which I am charged.
I will never reject
I will never reject
from any consideration
from any consideration
personal to myself
personal to myself
the cause of the defenseless
the cause of the defenseless
or oppressed,
or oppressed,
or delay any cause
or delay any cause
for lucre,
for
lucre, or malice.
or malice.
I will in all other respects
I will in all other respects
conduct myself
conduct myself
personally and professionally
and professionally
in conformity with
in conformity with
the high standards of conduct
the high standards of conduct
imposed upon members of the bar
imposed upon the members of the bar
as conditions
as conditions
for the privilege
for the privilege
to practice law in the state of Michigan.
to practice law in the state of Michigan.
You may put your hand down.
Thank you, Your Honor.
It is not unusual for almost counsel to stumble over the words of this oath. There is a movement to change some of the antiquated language, but I disagree with changing it. And the reason is because this has a long established history of compliance, and it sends a message that we are in the past and in the future to serve our community, our family, and our clients, and that history has stood and will continue to stand forever. This oath now, and I know you've taken others, I've taken the same ones as an officer in the Army, the Navy. We take an oath to serve, to protect, to defend. And as JAG officer, you've taken that oath. This now extends to the civilian world. And I know you've already been performing all of these promises. But now you have publicly stated and reminded your father, attorney, and all the attorneys in this room and who are watching of the commitment that we have all made. And that I know that you will uphold during your life with your family, with your clients, and in your community. So to never forget the oath that you've taken in public. I want you to approach and to affix your signature on the oath to memorialize this day and to always remember it. Please approach. And with that signature, should have been a doctor. Good. Step back. Mr. White, please approach.
Thank you, Your Honor. There you go.
I Having presented to the court the certificate of the State Board of Law Examiners showing that petitioner has been duly examined, fully qualified, and possessed of sufficient learning in the law, moral character, and ability to enable petitioner to properly practice in the courts of the state, therefore, on motion of Jonathan White, the court being satisfied thereon, it is ordered that petitioner be and is hereby admitted to practice as an attorney and counselor at law in the courts of the state. This has been read, approved, and signed in open court. We also have a certificate of admission that has been signed by this court as well as your father, lawyer, sponsor. And it reads that Jonathan Christopher White, having duly completed all prerequisite requirements, is hereby admitted to the practice of law in the state of Michigan with all rights and responsibilities vested therewith. Now, I don't know what other judges do, and nor do I care. I make sure that your oath and the certificate is on good paper. I can't order you to post it somewhere. Although they had some nice frames, might be in order for Christmas. You could put this in a file in your office or whatever you want to do with these. But I always like to ask counsel to please post them in your office, in your conference room, somewhere where when you meet with clients, they know the oath that you take. That when you are meeting with counsel, they are reminded of the oath they also took. Because civility seems to be more and more lost rather than found by counsel. And these gentle reminders are very, very important. So that is my hope for you, and that is my Christmas suggestion from dad to son. And sir, I want to say it is my profound honor and privilege to swear you in, having known you and your family. I think, well, I had cases when I was a lawyer with your dad 40 years ago. We've been around a long, long time. And it's always been my privilege to work with him and to hopefully now have you here in front of me. And knowing your character and what you stand for, I can't think of a better attorney to have been sworn in before this court. Being JAG officer, I wish I was still JAG. I miss it. Serving Navy was my first choice, but as a mom, I had to choose the Army National Guard. It was more family friendly. I have great respect for the Navy, had family serving in the Navy. And just what you've proven as a human being, I know that what you will always do is prioritize not the bottom line dollar, as some attorneys do, but rather your client. That you will always remember that the client that is with you is the only client you have, even though there might be 400 others in the drawer. You represent someone in crisis. You are their voice when we need one the most, regardless of what you are representing them in. And it doesn't ever matter whether you win or you don't. Because what's important is that every single client have their day in court, that they are well represented, because then we all win, and every client leaves the legal system thinking, hey, I mattered, I had my day. We have a good legal system, a good justice system, and good lawyers. And that is what I know you'll represent, and that is how I know your clients will feel. So that being said, please approach. And let's congratulate our newest Michigan lawyer. It is tradition in my court that since I had the honor and privilege of swearing you in, that I also have the honor and privilege of hearing your first words as counsel. Counsel.
Thank
In
you.
front of your family and friends, what would you like me to know?
First off, thank you so much. As you know, we do go way back, and I still have the letter of recommendation that you provided to me, which I've kept the original copy as a reminder of what started me on the immediate law school journey based on your confidence in me and your words of encouragement through that. Obviously, yes, this is my third jurisdiction, and so it makes it slightly different ceremony than maybe somebody who just passed the bar. However, being my home state, being the jurisdiction of my father, It's a very meaningful jurisdiction for me. And I will say that, yes, these will be framed, something I would do otherwise, whether it's from there or I saw. Just see a nod in the background. So it's, it's my pleasure to be here. I've done it on Tolak Miche in a few matters. But now being able to do it myself here and to carry on a tradition that was set forward by my father is very memorable and meaningful to me. So thank you again.
Well, and I wrote that letter a long time ago, but it was just, it was an honest letter that you deserved, but I didn't do the hard work. You did the hard work all of these years. So this is so earned and deserved. And it's really a privilege that you didn't stay in New York and that you come back to Michigan, because we're losing so many lawyers to other states. And so coming back home to roost and to practice is very meaningful, and really you're honoring our profession by being here. We now are a class act because you're in it.
Thank you.
Now, I'm going to open up the record. Does anyone else wish to address the court? If so, I know you're not criminals because you don't know where to go. You can't speak up just anywhere. You have to come up to the podium. So if you'd like to say something, you need to come to the podium.
And I assume,
Here we go.
can the Ohioans, can they be taken off mute and be heard?
Sure. All right, first let's hear from Mom.
Mom.
Please, oh, you gotta raise your right hand. Do you swear right up to the microphone?
Okay.
Yes, no criminal history there.
Okay.
Okay. Do you swear to tell the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
You may put your hand down. Please state and spell your name for the record.
Oh, Robin, Robin, White, White.
And what would you like me to know?
That this has been just an incredible experience. I was here when you swore Toby in, be here when I came alongside Chris as he applied, and your support has always meant a tremendous amount. And you bring a lot of character to the practice of law by emphasizing all the virtues that you want people to practice. And so we're thankful. We're thankful for your support for Toby and for Chris, and it's a great day and a beautiful ceremony.
Well, thank you. Thank you for raising a beautiful family.
Yeah.
All right, please raise your right hand. Do you swear or affirm the testimony you're about to provide me the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
And thank you for wearing a Christmas sweater.
Well, thank you for accepting my wearing the Christmas sweater, because
I have a Christmas outfit under here. I am required by law to wear this black robe, otherwise I would be in red and green sparkles, and I'll just show you. There you go.
wonderful.
Red, green sparkles.
Well, I appreciate it, Your Honor, because Zach Larson and I have a partner, Clark Hill, and had I been a little bit more prepared, I would have been court appropriate, but of course my office, my office's priorities today, of course, had to take precedence as well. So, but I can say, without hesitation here, I've practiced with Chris for the last 5 years. We worked on issues both locally and nationally in his government contracting practice together. He is of high, excellent caliber when it comes to his ability to practice. In terms of his moral character, I can attest to that as well. And I appreciate Your Honor's statement regarding really the eternal nature and intent behind the oath. The principles and the values that are there, and it was good to hear it again myself as a practicing attorney. But I can say without hesitation that I know that Chris will uphold those. I look forward to him being able to practice here locally. And I'm just proud to be here and a part of this.
Thank you, well said.
I only know what to do because they showed me first.
Please raise your right hand. Do you swear or affirm the testimony you're about to provide me the truth, whole truth, and nothing but the truth under penalty of perjury?
Yes, I do.
Please state spell your name for the record.
My name is Justina Sklodowski, Justina, Sklodowski, Sklodowski. I am just honored to be here. I don't know you personally, but I have heard so many amazing things about you. And from previous cases, I've seen how amazing you are. So the things that you said are just beyond meaningful. It's an honor for me to be here. I'm beyond proud of Chris, and amazing to have such an incredible man in my life and his family. So it's an honor to be here and I couldn't be more proud of him.
Thank you, very well said, and I know we've got some people on Zoom. And did you all, anybody wish to address the court from Zoom? You want to say anything? We're gonna unmute you. Right.
Speak up, Giorgio.
All right, so,
He ducked.
all right, we need you to unmute. So can you unmute yourself?
It didn't, Courtney.
Okay, you're unmuted. All right, so who's gonna speak? You need to raise your right hand. Are you all gonna speak? Okay. Do you swear to tell the truth, whole truth, and nothing but the truth under penalty of perjury?
I do.
You may put your hand down, please state, spell your name for the record.
Courtney Slonkoski, Courtney Slonkoski.
And what would you like me to know?
Yeah, the rest of the family is going to be too shy to speak up, but Chris is my younger brother, and it's a privilege to be here. And yeah, and I've heard so many great things about you. It's great to officially meet you over the screen, as it may be, but thank you for how much support you've provided for my dad and my brother. I know they really appreciate, they really value that. Georgia. So yes, it's been a joy for me to watch my younger brother grow into a man and now look up to him physically and also you know, from a moral point of view also. So we're so grateful to have him back here close to home after all those years out at sea and settling down here. And it's a privilege to be here. I echo what others have said about his moral character, that I have every confidence that he will contribute contribute with upstanding character and bring goodness to the Michigan courts. So thanks for allowing us to be here.
Thank you. So where do you live?
We live in a small town in Ohio, north of
Okay, well, when you come up to Michigan, you have him come with you and those kids, and kids, I see you there, you're a little shy. But when my kids, my twins were about your age, they came on my bench and I have a wonderful picture of them with this gavel. So we're gonna do that with you. How's that sound?
That sounds great.
That's the youngest one.
All right, so we'll just have a family picture, so that's in order for you, council, now to bring them in, and we're gonna have a picture of them on the bench,
Absolutely.
swinging that gavel.
I can do that,
right.
yes.
All right, very well said, thank you.
Gidget,
Did you wish to address the court?
Good afternoon, Your Honor. Yes, I will.
All right, please state your name.
Gidget James, Gidget James. I just want to congratulate Chris. I've gotten to know Chris over the last 6 years as I've worked with, of course, Toby. I know Robin. I think they are a tremendous family. I have no doubt that Chris will be an asset to the Michigan Bar. Congratulations, Chris.
Thank you.
Thank you, well said as always. I know you're sometimes shy to talk in court, but you always do such a good job. All right, well, that being said, it's picture time, and that is all for the record.
Thank you.
thank you, Your
Thank
Honor.
you.
Okay. So,
Where's
Ryan,
Elena? She's in.
okay, so first I need, this is kind of like a wedding, I'm just gonna order it. So, I need dad and, counsel, all right, first is with you. Yeah, back here. And Brian, you wanna help or take the pictures, or you can
Yeah,
just
I can do whatever.
come in front of there, you won't get my, you won't get this mess, we can, okay, we're gonna turn this off now. Or I'm gonna put this down, I guess they can watch it there.
Do you want me to come on the side and take it?
No, if you
Or
take
just
it,
come up like, oh, yeah, there you go.
you'll
That's-
see, you'll get this. Okay. Oh, here it is. Okay, so, I'm here. Shake it, get back. Toby, get back, okay. Just give me your left hand on the gavel right here.
There we go.
Toby, yep.
1, 2, 3. Beautiful.
Okay, before we change positions, I need mom and brother,
Not brother, but colleague.
or colleague, sorry.
Brother from another mother.
Yes. Yes. It's like a wedding, you're gonna do it a couple different jobs.
Sure.
Okay.
Okay, ready? 1,
Okay. Yeah.
oh, 1, 2, 3. Okay. Got it.
Okay, you, no, now you out, mom stay.
Okay.
1, 2, 3. Got him.
Toby, you out, mom stay.
Yeah, if you wouldn't mind. I'm gonna,
Yeah, sure.
we're getting out away from the desk. Okay, ready? 1, 2, 3. Okay,
Okay, would you like to come?
I would love to.
Okay. So I can just have just her be there.
Sure, we can do both. It's up to you. Do you want to take your coat off, or you're good with your coat?
Ah,
your coat off, it's a lovely outfit.
if you say so.
I say so.
It is a lovely outfit. She also brought
Oh, great.
I don't know off the record.
Okay, so I'm supposed to touch this too?
Sure, if you would like.
Okay.
All right. 1, 2.
Perfect.
Do you want me to take one of all of you?
Yep, you want everybody?
Sure.
Yep.
Oh,
Great.
you.
that's a good idea.
Yeah.
You want to go back, Chris, or was that stay there?
I've never heard that word.
Me
I
too.
don't know.
Oh, believe me,
I'll
nobody,
go behind
it's, there's a couple words in there that really need to go.
It's making the sound, but I'm like, let me get her to clarify.
Okay, get closer. Can you see
Oh, I
everybody?
can see everybody, yep.
Okay.
Okay, 1, 2, 3, hold still. Let me take one more, just a little bit closer up, okay. And 1, 2, 3, and there you go.
Okay,
You were
now,
thinking
everybody
about-
out. Did you get one? Did you get one of just the two of us?
I don't think we did
Yeah,
that.
okay.
Watch
You mean the
yourself
center? Okay.
Thank
on that. I
you.
was thinking we
Just- Okay, and 1, 2, 3, and one more. Okay.
Okay,
Sorry.
do you want any others?
I think we're.
No, I think we're
I think
good.
that's great. All right.
Oh,
Right now,
Oh, you need it back?
and we'll use an envelope for you and, yeah. Did you want to give them a copy?
Yeah.
Yeah.
I'll bring it right back over.
Bye, guys.
I haven't got to that page yet.
I'll be right back with it.
Now they all.
Yeah,
Thank
wave,
you.
wave goodbye.
Oh, Ellie's in there hiding.
Yeah, Ellie's there, I saw her.
Yeah.
Hey,
Hi,
Ellie.
Ellie. And I don't know where Josh is.
I mentioned
Josh
it.
was there.
I never saw him.
I was waiting till we were off the record.
Where's Josh? All three of us know.
Oh, my gosh.
I
Thank you.
promised you I was gonna buy them to read them.
Oh, gosh. Yes. Wow.
Oh, you have your book signed?
Okay, so spell your name.
JUSTINA.
Okay. Thank you.
Thank
You
you.
should use sign language.
They probably still hear us.
Oh,
I will.
You're so, you know, they really small.
Cat phone now.
Excited for this.
As long as you don't have during, you know.
The whole
And
thing.
most days I-
Yeah.
But what an incredible idea.
Oh, gosh, I just.
You could write down where's Josh.
Oh, yeah, that's right.
Oh, there-
Captain.
I saw him in
Inspiring.
there once earlier.
Yeah. Okay,
Well-
zoom
They're so goofy.
in. Fulton with his binoculars
Yeah.
on, and Captain's front and center now.
He's so good.
Yeah.
It's funny. I wonder if Josh.
Sometimes it's like, I can't afford some of that
Yeah.
time to break.
Well, now it's very-
Oh.
Now he's doing an elephant's touch with a Congress. I know I can make everybody laugh.
So much
Thank you,
bigger.
appreciate it.
Yeah.
And
Ellie was so
Did you
fast.
see her come into it?
She looks like a really young woman.
Yeah.
They're all beautiful kids. She'll be 13 in February, so now we're getting 7 again. I bet
We'll
Ellie's
get those
down there
frames.
doing
We'll
that.
get some special.
So are you on frame duty?
Sure,
Okay.
we'll get some
One of,
special
one of
ones.
us has to.
We can do it together if you want.
We'll go,
If we don't get it done, we'll be going out that metal door.
You
then.
want to-
I'm not trying to get in trouble.
no, I was just talking to Steve, though. I need to go to Safer Gallery. They don't all way on their
Yeah,
frame, so we can just have.
we can do that.
They do a good
Wherever
job.
you wanna go.
Yeah.
You definitely have to get them and put them up.
Pretty easily.
Bull in China show.
Yep. Looks sturdier. I'm a leader like this. It does swivel.
Swivel, yeah.
I'll also have you know that, July 18th, you're gonna be invited.
Where's the
to our-
projector?
Oh, good. So you don't have, I'm not gonna power it. I mean, you want to?
Well, probably, yeah.
But yeah, we talked about it. He was like, we have to talk to us. So,
Yeah.
If you're looking for someone to perform,
Option.
present, you may want to.
Okay, so
Yeah.
I'm
it's-
not-
it's-
I'm not.
There will definitely be a
We
priest.
know
Yes, I
Closing.
know.
Closing,
Closing,
you
you're
need
opening, you want
something in
to
front of
be- you
you,
walk in on it,
where you're
yeah.
working through.
Father
the
Ryan.
Exactly.
He loves Father Ryan.
things.
I will send
Well, that's
you the
productive.
bajillion pictures that I have. Okay. Might take a couple of minutes, but they'll come through.